live from the drama free true crime destination. It's your Wednesday check in with truth, talk, and the stories that won't let go. This is the Mid-Week Byte. And a good Wednesday evening for you. Welcome to the Midweek Byte. I'm Ernest Bethea, the last outlaw. So good to have you aboard. And I have got an 8-piece for you just to let you know and give you a reminder about how justice truly is. In fact, that is going to be my brief, keyword brief, opening statement to you all. So let's get to it. And pardon me if I'm not showing my face at the moment. Give me one moment. There's that. And da. Here I am. How you guys doing? Ernest Bethea, the last outlaw. So good to see you. This is my opening statement. Justice is a promise, but it's not always a guarantee. Tonight, we examine 8 stories that stretch across the spectrum of accountability, consequence, and closure. From high-profile sentencings and overturned verdicts to delayed hearings and restitution orders. These cases reveal the complex machinery of our legal system. Some victims find resolution, some families remain in limbo. Some outcomes raise more questions than answers. This isn't just a roll call of courtroom drama. It's a reflection of how justice is delivered, deferred, or denied. Welcome to the Midweek Byte, folks. Let's get this ball going underway. Hey, we're going to start with a little bit of a delay. Rebecca Harrow, remember her? If you don't, let me get you up to date. This is the mom whose infant son is missing in California. Her husband has already pleaded guilty in the death of this little boy. Now, her case is being delayed. In fact, it's being pushed all the way back to 2026. Let me go ahead and get the screen set up for you. And let's get down to business. Oh, and by the way, that's not Rebecca Harrow. That's Judge Ashley Wilcott of Court TV. Here's the article, and then I'm gonna let her break it down for you. Rebecca Harrow, as you can see on the right hand side of this article here. Rebecca Harrow, the missing mother of missing baby Emmanuel Harrow, was in court briefly on Tuesday, nearly 2 weeks after her husband pleaded guilty to murder.
Let's turn now to California, where the mother of missing baby Emmanuel Haro was back in court. Rebecca Haro is accused of murdering her 7-month-old son and then telling authorities he had been kidnapped. Haro's husband Jake pled guilty to the murder earlier this month, but Rebecca has not changed her plea. Joining us live in studio now to break it all down is Court TV crime and justice correspondent Matt Johnson. Thank you, Matt, for being with us.
Of course.
You've been covering this case. I understand today's hearing was short. Tell us about it.
Very important, Judge Ashley. And the case continued again. Mother of missing baby Emmanuel Haro back in a Southern California courtroom today and asking for her settlement conference to be pushed again, this time to January of next year. Rebecca Haro's last court date was moved after her husband's shocking change of plea right before his settlement conference was set to begin. Earlier this month, confessed killer Jake Haro pled guilty to murder of 7-month-old baby Emmanuel. Back in August, you remember, both parents were charged with murder, child endangerment, and filing a false police report. Well, today, Rebecca Haro agreed to move her settlement conference by 85 days. Take a listen.
Ms. Haro, you have the right to have your preliminary hearing heard within 10 court days, concluded within 60 calendar days of your arraignment. You waive those rights and agree instead that your preliminary hearing would be timely if held within 10 court days of January 21st. Ma'am, you're ordered back to this department on January 21st for felony settlement conference.
At this point in time, still no indication if Rebecca Haro, the mother of this baby, is looking for a plea deal. But the settlement conference and now the preliminary hearing have been moved to the end of January.
That's a big deal. I know we'll stay tuned and see what happens. But tell us about Jake entering the guilty plea. What's next for him?
He's back in court on Monday. It's going to be another big day, November 3rd, for his sentencing. Now, on Monday, we can expect those victim impact statements and possibly a statement in elocution from this confessed killer, Jake Haro, before his sentencing. Haro faces 25 years to life behind bars, but it's up to the judge to determine the sentence, since his change of plea was with the court and not the Riverside County District Attorney's Office.
How do you plead to the charge in count 1 of the amended felony complaint of violation of Penal Code Section 187A?
I'm guilty.
And for clarification for the record, that's going to be in the second degree?
Yes.
Sir, do you admit that you committed a violation of Penal Code Section 187, Subdivision A, a felony, in that on or about August 5th of 2025 through and including August 14th of 2025 in the County of Riverside, State of California, you did willfully and unlawfully murder baby doe, initials EH, a human being?
I admit.
Audio from that recording from that hearing and a photo of him appearing to cry there in court. Baby Emmanuel's remains have never been found, not located. On Monday, Haro has the opportunity, Judge Ashley, to give that statement in elocution and just say where the baby is. He's admitted to killing that baby.
And a judge cannot force anyone to say anything, including where the baby is, but here's to hoping he does choose that route.
Exactly.
Matt Johnson, thank you so much as always.
Where is baby Emmanuel? Which one of them is going to be the first to speak up and say where that little boy is? Which one is going to be the first one to say, well, in a sense, Jake has already done it. He's basically saying, I did it. But the question is, why? What could that little boy have done to deserve to be just tortured, abused, killed? So I guess I got a couple of important dates to come. November 3rd and January 2026. I just wish I didn't have to wait for that January date. Moving right along, we're going to go to our next story. Oh, by the way, just for the record, that's what we call justice deferred. All right, next up. Sean Diddy Combs is going to get an early release from prison. It'll be in 2028. How so? Here's how so. Okay. All right. I can get this right. Okay. All right. Disgraced hip-hop mogul Sean Diddy Combs has been awarded a release date as he settles in to serve his sentence on federal charges. Combs was convicted on 2 counts of transportation to engage in prostitution in July by a jury that cleared him of the more serious charges of racketeering and sex trafficking. In October, Judge Aaron Subramanian sentenced Combs to 50 months in prison, despite his attorney's pleas for mercy and a sense of time served. Prosecutors had requested a total of 11 years. The prison now lists Combs as having a release date of May 8th, 2028, which accounts for the time he has served since his September 2024 arrest. The Federal Bureau of Prisons still shows Combs as being held at the Metropolitan Detention Center in Brooklyn. Judge Subramanian formally requested at the urging of Combs' attorneys that Combs serve his sentence at a prison in the New York area. Combs was fined $500,000 for his convictions. His attorneys have pledged to appeal both his convictions and the sentence. Honestly, you got the sentence. You're getting out in a few years. That's the best way I can say it. A few years. And it's only going to cost you a good $500,000 compared to what you got, compared to what you could have gotten. Let's be totally honest with yourself here. You've been found guilty. You can appeal if you want to, but you're only supposed to be doing what? 50 months? 50 months. So let's see. That's what? 4 years and 2 months. If it's that hard for you, then like the saying goes, don't do the crime if you can't do the time. I don't care how big your name is in the music business. Oh boy. All of a sudden my phone decides to go off. There we go. There we go. Now, as I was saying before my phone went off, don't do the crime if you can't do the time. You could have gotten a lot worse as far as your sentence go. Heck, those racketeering and sex trafficking charges could have put you in for a lot longer time. But hey, Be ever so grateful you've got only this long, because this is the kind of case that could have set you back and set you. I mean, you're sure your name is already mud now. Your name is already mud now, but it could have been a lot worse. So good luck, Diddy. You're gonna need it. Someone else is gonna be a little bit lighter in the wallet. That being Lori Vallow Daybell. Lori Daybell has been ordered to pay restitution to the grandmother of JJ and Tylee. Honestly, this is one of those this couldn't have happened to a nicer person type cases to me. Here's the article, and then we'll take you right to Court TV for the breakdown. A Maricopa County judge ordered Lori Vallow Daybell to pay restitution to Charles Vallow's family during a hearing last Friday, adding financial consequences to her multiple life sentences for a string of murders and conspiracies. Judge Justin Bereski approved restitution payments nearing $12,000 to Kay Woodcock, the sister, oh, I stand corrected, the sister of Daybell's fourth husband, Charles Vallow, not the grandmother of JJ and Tylee. I apologize for that right here, right now. The restitution followed Daybell's sentencing in July when Judge Bereski sentenced her to consecutive life terms for conspiring to kill Vallow and attempting to kill Boudreaux. Those sentences were added to the life sentences she's already serving in Idaho for murdering her children, Tylee Ryan and JJ Vallow, and conspiring to kill Tammy Daybell, the first wife of her fifth husband, Chad Daybell, who, if you're keeping score, is about to is on death row for his part in that crime. During Friday's hearing, Daybell displayed the same defiant attitude that characterized her previous court appearances. When Judge Bereski asked about her drug use history as part of standard restitution proceedings, Daybell responded with sarcasm, making flippant remarks about her incarceration that drew sharp rebukes from the judge. The restitution amounts reflect the extensive costs the families incurred due to Daybell's crimes. Woodcock sought compensation for funeral expenses, lost income, and other damages related to Vallow's death. Restitution amounts are still being calculated in Boudreaux's case, according to the East Idaho News. Daybell was convicted in April of conspiracy to commit first-degree murder in Vallow's death, and in June of conspiracy to commit first-degree murder in the attempt on Boudreaux's life. She represented herself in both trials, often clashing with prosecutors and the judge. Cox, who carried out the shootings of both Vallow and the attempt on Boudreaux, died of natural causes in 2019 before he could be charged. Chad Daybell, convicted of the same Idaho murders as his wife, and sentenced to death. And here's an editorial edit here. A previous version of this report inaccurately stated that Daybell was ordered to pay $2.4 million to both families. So no, it's not 2.4 million. It's 12,000 to Kay Woodcock at the moment. Still wondering what that's for. But that'll be for Boudreaux. Now for the breakdown of that whole hearing, we're gonna go to Court TV, and we're gonna get that covered by Kelly Kraft and Julia Janae.
Turning now to Arizona, where Lori Daybell has been ordered to pay her late husband's sister nearly $12,000 in restitution.
Yeah, the cult mom killer appeared via Zoom at the hearing that took place last week in Arizona. She's, of course, in prison in Idaho. And she appeared to become a bit irritated when she discussed how much she'd have to pay Kay Woodcock, the sister of Daybell's fourth husband, Charles Vallow, who she was found guilty of killing earlier this year. Let's take a listen to this hearing.
All right, I called the case. Let's have a state announce.
Trina Kay on behalf of the state.
And defendant.
Lori Daybell for the defense.
All right, I can hear everyone fine. This is the time set for restitution hearing. Have there been any agreements?
Your Honor, I am not sure. I was going to check with Ms. Daybell if she would stipulate to anything. I do have one correction in the documents on bait stamp 101133. What we've learned is that the gas receipts that were provided are not all of the gas receipts, and so that's why we had done the mileage, but we forgot to remove the gas receipts themselves. So we should actually remove $348.98, which would make the total restitution request $8,600.54.
Okay, I'll ask the defendant, are you stipulating to any restitution?
Your Honor, on Wednesday night, I did receive those Bates numbers that were supposed to be given to me from my advisory council. They mailed them to me. I just got them. I was able to review those. Those ended at Bates number 101161. And yesterday I was informed by my advisory council that the state sent over one more document on Tuesday by email to my advisory council, and I have not seen that document. It's Bates number 101162. It is my understanding, since I talked to my advisory council yesterday, that that document is a document. They kind of explained what it was to me. And so my understanding is, and although I'm aware that counseling, thank you. Although I'm aware that counseling costs can be included in restitution, this document turned over by the state is an Excel spreadsheet totaling $3,147 in counseling. There are no invoices from doctors or insurance companies to my knowledge. So the document in and of itself seems to be insufficient. I haven't actually seen it. However, based on how my trials were conducted, since experience tells me that regardless of what I say or what anybody else says, you're going to order it, I am willing to stipulate today. It is my understanding that I have already been ordered by this court to pay over $534,000 in fees, in fines, surcharges, and court fees. So you can add Ms. Woodcock's total of $12,096.97 of restitution to my tab.
And Your Honor, with that correction, it would actually be $11,747.99.
Hold on, $11,740.
$7.99.
All right, Ms. Daybell, you're stipulating to pay restitution to Kay Woodcock in the amount of $11,747.99. Is that correct?
That's correct.
Any drugs, alcohol, or medication in the last 24 hours that would affect your ability to make this decision?
Have I been on any drugs, Your Honor? Is that what you're asking?
No, I'm asking, have you had any drugs, alcohol, or medication that would affect your ability to understand or make this decision today?
Is Your Honor aware that I am in prison? I have no access to any of those things. So no, the answer is no, I have not.
Thank you for answering the question. Has anyone promised you anything in exchange for your agreement to pay this restitution?
No.
Has anyone forced you, threatened you, or coerced you to get you to agree to pay this restitution?
Only my trials, Your Honor, coerced me.
All right. The court finds that your agreement is knowingly, intelligently, voluntarily made. It's ordered that you pay $11,747.99 in restitution to Kay Woodcock. The restitution would take priority over any other fines and fees that have been imposed. And it's ordered that that restitution be paid out at the maximum rate allowable out of any prison account. Ms. Kay, do you anticipate any other restitution requests?
Your Honor, we are still awaiting restitution requests from Brandon Boudreau. I know that he's been busy with work and he hasn't got all of those documents together. When I get those, I will submit them to advisory council and to Ms. Daybell's investigator, who seems to be able to get that to her much easier. And just for the record, Ms. Woodcock is still ongoing counseling, so there could be subsequent requests.
Well, the court retains jurisdiction over the matter of restitution for the period that the defendant is serving a sentence. So I'm not setting any further hearings at this time. We'll wait and see if any requests for hearing come in. All right, thank you. We'll be at recess.
All right, that concludes that hearing. Still with us, trial attorney Jamie White. Jamie, all right, we saw Lori again there, and she seemed to be in good spirits and bantering back and forth, letting the judge know she's in jail. So, of course, she's not on drugs or alcohol.
Yeah, she's got quite a bit of energy still, which is surprising. You know, it would be somewhat humorous if there weren't for the fact that there's multiple dead people associated with Miss Daybell, two of them her own children. You know, the unfortunate thing I think is going on here is that, you know, the victims have to see this. They're never going to see this money, but the court has to go through these processes. And I've heard victims say, you know, it's almost a poke in the eye, you know, to have to deal with these restitution issues when, in fact, there's likely never any money coming forth.
Yeah, I wanted to know that, Jamie. For our viewers, I'm sure they're wondering, we often show this, or we hear it at the end of a sentencing, that someone is ordered to prison for the rest of their life, but they're also ordered some restitution amount. What is the reasoning behind it when we know someone's going behind bars and they're not making any money when they are there, but there are situations where restitution becomes very important?
Yeah, absolutely. And, you know, we can't predict the future. Strange things have happened. Laws change. People sometimes are resentenced under certain circumstances. Sometimes people come into money while in prison. As unlikely as it is, it does happen through inheritances and other sorts of mechanisms. So it's important that the process play itself entirely out. As frustrating as it might be for the courts, the players, the defendants, the victims, it's important that it play itself out, but it can be extremely frustrating for the people who are on the receiving end of nothing.
Yeah, it's an effort to make the victims, those who were impacted, whole. And but yeah, it's always interesting. I know even like in the Diddy trial when we were just there, you heard, I think his restitution was something like $500,000. I can't remember exactly.
Oh, now that can be paid out.
That one for sure can be paid out.
The access. Well, how did she look to you, Kelly? I know you've been in the courtroom with Lori Vallow Daybell.
You know, she looked like her normal self. When we were covering that trial out there, she'd come in, spirits high, smiling at everyone that was in, you know, in the courtroom, and looked the same here. in good spirits. She's doing fine, it seems like.
And that's where we'll leave it with the Vallow case. Jamie White, thank you so much for your analysis this entire hour. We really appreciate it.
And that's the way it looks for Lori Vallow Daybell. And honestly, she can be as sarcastic as she wants to. The simple fact of the matter is she's doing time for murder. She's doing time for a conspiracy to commit murder. And she's got money to pay back. And like I said, this is one of those, this couldn't have happened to a nicer person type cases. And being smart and snippy with the judge is not really going to help her cause either. So enjoy spending the rest of your life in prison, Lori. But a lot of it's got to come out your pocket too, in some way, shape, form, or fashion. Also, yeah, that's still, by the way, justice served. And speaking of justice served, in case you missed me on Monday, I was here live for a special report on the sentencing of Bianca Ellis, who was convicted of murdering 3-year-old Julian Wood. And attempting to murder his mother. If you missed it, here's the coverage of the sentencing.
I don't say that to minimize any of the comments that were made, but I do take in everything, right? So I don't come up here on the bench without some idea of what the court may use as the tools under the revised code section to move forward with sentencing. And so I'll say to the Woods family, nothing I say here will ever capture the enormity of your loss. This court recognizes that your lives were forever changed on June 3rd of 2024. Understanding your comments, I thank you for them. No sentence I impose today will make you or your family whole again, and you know that. I do want you to know that I acknowledge, even similarly as Mr. Mack said, your courage, your hopes, and today my hope is that this brings some measure of closure for you to continue to move on in your lives. As you continue to navigate the landscape of life without your son, please know that I'm painfully aware of Julian's void in your lives. Justice cannot undo tragedy, but it can affirm that what happened was wrong and that your child's life mattered. And to the Ellis family, you've been here the whole time as well. I do want to acknowledge that this process as well has been painful for all of you. As a family, you must forge ahead and try to understand the nature and gravity of this case. Again, while my sentence must reflect the severity of the crime, I do not ignore that your family too are experiencing loss. And I hope that you find strength in the days ahead. Ms. Ellis, as noted, the jury of your peers has spoken. They have found that although we all have agreed that you suffer from schizophrenia, that you did understand the nature and wrongfulness of your actions as handed down in all of the guilty verdicts by this jury. You know, the power of the American jury system is that it reflects the values of all the community that they represent. And as I sit here as a judge for almost 21 years, as a court, I accept the finding of your peers, and I'll sentence accordingly. You know, the tragic sequence of events of June 3rd of 2024 and that attack, the jury has found was calculated and wholly without justification or reason of any kind. You know, I rewatched every video for preparation for sentencing that was presented during the trial. And I find that it's clear that in that evidence, you are fixated on the very first child that you crossed paths with that tragic day. That tragic day, you chose to end the life of Julian Wood. A life, as we heard today, that was filled with limitless promises. Your choice has inflicted immeasurable pain on the Wood family, on your own family, and as we heard, on the community in which we all live. Mental illness does not excuse what you did. Although it will be taken into consideration when you are sentenced, that you continue to receive ongoing treatment while incarcerated. Ms. Ellis, I hope that you use this time to confront the harsh reality of the actions that you've created here in the courtroom. No sentence that I hand down today can undo the pain that you cause, but justice requires that your actions have consequences. Before concluding with my sentence and outlining what I will hand down today, I do want to take a moment to address an issue that confronts this court and our communities near and far. This tragedy did not occur in isolation. As a society that cares for the members of the community, we cannot continue to ignore the glaring gap in our county's mental health support system. It is not lost on this court that this trial started during Mental Illness Awareness Week, a week that recognizes the importance of meaningful connections, advocacy, and local actions to ensure that adequate mental health services are available to each and every citizen here in Cuyahoga County. Significantly, the medical experts in this case testified on October 10th, a day that was globally recognized as World Mental Health Day, a day that's dedicated to raising awareness around mental disorders and combating their social stigma. It's in this spirit, I hope we all continue to confront the gap between the need for mental health treatment and its effective and equitable distribution and provision to all of those in our community. And therefore, I urgently implore our city and county leaders to continue providing facilities and programs that respond quickly and compassionately to those in crisis. The need is dire now than far too many of us realize. The leaders in this county have been discussing this topic for far too long. Please get it done. No family should have to lose a child, and no family should have to watch their loved ones deteriorate because meaningful and effective mental health services were unavailable. The absence of adequate and functioning mental health facilities in our community has tragic consequences. And I call upon our leaders at every level of government to make providing and supporting mental health care a true priority so that others in crisis can be helped before another tragedy occurs. But Ms. Ellis, again, I want to state that while your mental illness was accepted by this jury, it is not an excuse for what you did. The jury found that although you suffer from schizophrenia, you understood the nature and wrongfulness of your actions. and handed down their guilty verdict on all charges. When reviewing the sentencing factors as outlined under 292911 and 292912, my job as a judge here is to punish the offender, but also to make sure that the sentence should be proportionate and not demeaning to the seriousness of the offender's conduct and the impact on the victims, and consistent with other sentences with similar crimes. In looking at the seriousness, of course, the child's age and the suffering weigh heavily for this court as well. And so with respect to my sentencing, after taking in consideration all the matters before the court that are appropriate under the principles and purposes of sentencing, the court's going to impose the following sentence. Starting with count 2, as found guilty on count 2 of murder, it's a life with parole eligibility at 15 years. On count 3, the murder charge under the B section, it's life with parole eligibility at 15 years. And those are the maximum sentences that can be handed down on those 2 counts. On count 4, with respect to the Reagan-Toke sentencing guidelines, count 4 and count 8 are both felonies of the second-degree felonious assault. We also speak to count 5, which was the endangering children as a felony of the second degree. And then we speak to count 7 and 6. The state and I have agreed that I will move forward with count 7. Under count 7, under the Reagan-Toke sentencing guidelines on the attempted murder in count 7, the court's going to hand down the maximum sentence of 11 years as the minimum sentence to the indefinite sentence of 16 and a half years. Again, I've outlined the Reagan-Toke guidelines and the reporting requirements for post-release control that will be controlling on all other felonies of the second and first degree, this being the highest level. I've outlined the 5 provisions, as I noted for the record already. And then with respect to the count 4 and 8, the maximum sentence is 8 years. I'll hand down that sentence. Count 5, 8 years. Count 6, 11 years. Count 8, 8 years. And then as indicted, count 10, which would be a 6-month sentence on the misdemeanor charge. Regarding aggravated murder and finding the defendant guilty of aggravated murder by this jury, the court's going to hand down a sentence of life without parole. I'll run every other sentence concurrent to life without parole. Ms. Ellis, you'll be given credit to 509 days of time that you've served. I'll order you in the custody of the sheriff to transport you to Marysville Correctional Facility. I'll also indicate that fines, fees, and court costs will be waived with respect to the sentence. In addition to the verdict that has been handed down by this jury and the sentence that the court handed down, Ms. Ellis, you have a right to appeal both the sentence and the conviction in this case. You can do that by filing a notice of appeal with the clerk of courts within 30 days of this sentence. If you're unable to pay for the cost of an appeal, you have the right to appeal without payment of costs. If you're unable to obtain counsel for an appeal, I'll appoint counsel to represent you. If you're unable to pay the cost of documents necessary, they are provided to you without cost. You have a right to a notice of appeal filed timely on your behalf. And Ms. Ellis or counsel, do you wish to appeal both the sentence and the conviction handed down in this case?
Yes, Your Honor. No objection for the record, and appoint counsel for the appeal.
I'll note your objection regarding my sentence, and knowing that she's unable to afford counsel, I'm going to appoint the public defender to represent her with respect to her appeal. Again, noting for the record, all counts will be run concurrent to each other, with the life without parole being count 1 sentence. I'll waive all fines, fees, and court costs, give her credit for the 509 days that she served, in addition to time while she awaits her transportation to Marysville Correctional Facility for Women. Is there anything further from the state of Ohio before we recess?
No, Your Honor.
Anything on behalf of Ms. Ellis?
No, Your Honor.
All right, we adjourn. Thank you.
Yeah.
Now that's when I have to ask the question, why waste time? The video doesn't lie. In fact, I can see the surveillance video in my head right now as if I were watching it months ago. Ellis walks into the Giant Eagle grocery store with an 8-inch butcher knife in hand. She is on my left side walking one way. Margot and Julian are coming down the opposite way on my right side with a shopping cart. Ellis executes an about face and follows them in that very same direction. Then, following what the report said, Ellis stabbed Margot in the shoulder, stabbed Julian in both the face and back. Sure, we can say that she's dealing with schizophrenia, but for her to grab a knife from the Volunteers of America store and choosing which one to use, that's a choice of her own volition. And then she made the choice to go walk into that store with the knife in hand, chose to turn right around and follow Margot and Julian Wood out the store into the parking lot and stab both, killing the 3-year-old. Yes, she acknowledges what she did. Okay, that's not a problem. You done the you've done the crime. Now it's time to do the time. And that's exactly what's going to happen here. Let's see, what's next on my docket? Justice served once again. We have an Illinois deputy convicted of murder in the shooting of Sonia Massey. Oh, like I said, some cases where justice is served, some may surprise you, some may give you joy, some not so much. In this one, that depends on how you hear all this. In fact, I'm just going to go ahead and read this article and get it over with. Take a look at your right-hand side of the screen. That's Sean Grayson. An Illinois jury on Wednesday, today, convicted a former sheriff's deputy of second-degree murder in the shooting of Sonia Massey, a black woman who called 911 asking for help. 31-year-old Sean Grayson could face up to 20 years in prison or probation. Sentencing is scheduled for January 29th, 2026. Grayson and another deputy arrived at Massey's home in Springfield, Illinois early on the morning of July 6, 2024, after she reported a prowler. Grayson shot the 36-year-old woman after confronting her about how she was handling a pot of hot water she had removed from the stove. Grayson and his attorneys argued that he feared Massey would scald him with the hot water. Massey's killing raised new questions about U.S. law enforcement shootings of black people in their homes and prompted a change in Illinois law requiring fuller transparency on the background of candidates for law enforcement jobs. Grayson originally was charged with first-degree murder, which carries a prison sentence of 45 years to life, which must be served in full. But after a 7-day trial, the jury was given the option of considering second-degree murder, which applies when a defendant faces a serious provocation or believes their action is justified even if that belief is unreasonable. Second-degree murder could bring Grayson a sentence of 4 to 20 years with day-for-day good time, meaning his sentence could be halved if he behaves behind bars. He could also be sentenced to probation and avoid prison time entirely. Body camera video recorded by the Sangamon County Sheriff's deputy on the scene that morning, Dawson Farley, was a key part of the prosecution's case. It showed Massey, who struggled with mental health issues, telling officers, "Don't hurt me," and repeating, "Please, God." When the deputies entered the house, Grayson saw the pot on the stove and ordered Massey to move it. Massey jumped up to retrieve the pot, and she and Grayson joked about how he said he was backing off from the hot steaming water. Massey then replied, "I rebuke you in the name of Jesus." Both Grayson and Farley drew their pistols and yelled at Massey to put the pot down. Grayson told investigators he thought her rebuke meant she intended to kill him. And, in the following commotion, fired 3 shots, striking Massey just below the eye. Farley, at the time of the shooting, was a probationary employee subject to firing for any reason, testified that Massey didn't say or do anything that caused him to view her as a threat. But under cross-examination, he acknowledged that he initially reported to investigators that he feared for his safety because of the hot water. Farley did not fire his weapon and was not charged. Grayson testified in his own defense and was the first witness his attorneys called. He told jurors he noticed the bottom of the pot was red, and he believed Massey planned to throw water at him. He said Massey's words felt like a threat, and that he drew his gun because officers are trained to use force to get compliance. "She's done. You can go get it, but that's a headshot," Grayson told Farley after the shooting. "There's nothing you can do, man." Grayson relented moments later and went to get his kit while Farley found dish towels to apply pressure to the head wound. When Grayson returned, Farley told him his help wasn't necessary, so he threw his kit on the floor and said, "I'm not even going to waste my med stuff then." Prosecutors said that response indicated Grayson's disregard for public safety, an argument that persuaded Judge Ryan Cottagen to keep Grayson in jail awaiting trial. An Illinois appellate court subsequently ruled that Grayson should be released under the Pretrial Fairness Act. An appeal to the state Supreme Court has yet to be decided. Massey's death also forced the early retirement of the sheriff who hired Grayson and generated a U.S. Justice Department inquiry. The federal probe was resolved with Sangamon County Sheriff's Department's agreement to fortify training, particularly de-escalation practices, develop a program in which mental health professionals can respond to emergency calls, and to generate data on use of force incidents. Massey's family, with the assistance of civil rights attorney Ben Crump, settled a lawsuit against the county for $10 million, and state lawmakers changed Illinois law to require fuller transparency on the background of candidates for law enforcement jobs. Now, before I give you my commentary on that, I am going to look up the word rebuke. Okay? According to Oxford Dictionary, rebuke express sharp disapproval or criticism of someone because of their behavior or actions. That's the verb. As a noun, it's an expression of sharp disapproval of criticism. And just to add a little more context, the woman Sonia Massey did say to Grayson that she rebuked him in the name of Jesus. So what does that mean from the Bible standpoint? It's used to convey a strong expression of disapproval, reproof, or correction. It often implies a stern or sharp criticism intended to correct someone's behavior, attitude, or actions. The concept of rebuke is closely tied to discipline, correction, and the pursuit of righteousness. Now that we have that clear, Sonia Massey rebuked Sean Grayson in the name of Jesus. Her words. And why did she do so? He was fearing a pot full of steaming hot water, thinking that Sonia Massey was going to throw the water at him. They even joked about that. Until the point Massey said, "I rebuke you in the name of Jesus." I mean, all he had to do was make that clear to her. Ma'am, please put that pot down. I don't know what you're going to do with that thing, but that thing is that pot is a danger to me. Please put it down. But instead, I guess he decided he was going to shoot first and worry about the consequences later. Well, the consequences are about to hit you right now in another couple of months, because Mr. Grayson, formerly Officer Grayson, is going to deal with the consequences come January 29th. And really, this is going to depend on what the judge decides. If it could, like the article said, he could face 20 years in prison or 20 years probation. Or probation. He didn't say 20 years on that. They did just say probation. So this could end one of two ways. It could end up as justice served or justice denied. Right now, it just hangs in the balance here. All right, let's see what we got next on the docket. This one I'm already counting it as justice denied. A Florida appeals court is overturning a $213 million judgment for Maya Kowalski. All right. we're gonna get you to the covers in just a minute. Right now, we're in St. Petersburg, Florida, for this one. A Florida appeals court has struck down a $213.5 million judgment awarded to a family who claimed a hospital held a child captive and led to her mother's suicide. Maya Kowalski and her family won their lawsuit against Johns Hopkins All Children's Hospital, with a jury awarding them more than $250 million, which was later reduced to $213.5 million. The Kowalski family was subject of a Netflix documentary, Take Care of Maya, which chronicled Maya's battle with complex regional pain syndrome, a neuropathic disease that causes extreme pain. Maya's previous treatments of high-dose ketamine and complaints of frequent pain prompted hospital officials to report suspected abuse. That report escalated to the point that her mother, Bethea'S Kowalski, was not allowed to visit or speak with her daughter. Bethea'S died by suicide while Maya was in the hospital. While the jury sided with the Kowalskis, who said that Johns Hopkins All Children's Hospital was liable for false imprisonment, battery, fraudulent billing, wrongful death, and causing emotional distress, an appeals court said they were wrong. In a decision filed on Wednesday, the Second District Court of Appeals said that the trial judge should have dismissed the claims of false imprisonment and intentional infliction of multiple distress, as well as others. The appeals court conceded that the emotional distress may have led to Bethea'S suicide, but said the trial court should have dismissed the wrongful death claims and others because Johns Hopkins All Children's Hospital was protected by state law. Florida law section 39 details child abuse reporting guidelines under which the hospital was required to report any suspected abuse. Once that report was made to the Department of Children and Families, the hospital became an agent of that department for the purposes of detaining Maya and keeping her away from her mother. Beyond the initial detention and reporting to the department, the legislature has placed no burden on the person detaining the child. Instead, it has placed a burden on the department. Under that logic, the appeals court said that most of the claims levied by the Kowalski family are moot. The ruling strikes down the full judgment and reverses the jury's findings. Because of its ruling, the appeals court said there can be a new trial only on the remaining issues for which the hospital is not immune. Claims of intentional infliction of emotional distress from Maya, as well as battery and medical negligence. In a statement to Court TV, Ethan Shapiro, who represents Johns Hopkins All Children's Hospital, said this opinion sends a clear and vital message to mandatory reporters in Florida and across the country that their duty to report suspicions of child abuse and, critically, their good faith participation in child protection activities remain protected. The facts and the law have always prioritized protecting children, the most vulnerable among us. And now, here's that breaking news as it happened.
Breaking news, a Florida appeals court has just overturned the $213 million judgment for Maya Kowalski. You saw this trial right here on Court TV, the Take Care of Maya's civil trial.
There's a Netflix series on that as well. It was a riveting case. Maya Kowalski and her family sued Johns Hopkins Children's Hospital, claiming that its actions led to Maya's mother taking her own life. There was a big part of it, the emotional side of it. Trial lasted 8 weeks. Jurors heard from family members, doctors, nurses, and tons of experts.
That's right. And ultimately, the jury, after listening to all of that, found the hospital liable on all 7 counts, including false imprisonment, medical negligence, battery, fraud, and intentional infliction of emotional distress on the family. Now, here's what the appeals court said, though. The appeals court has found that the trial court erred in the interpretation of the law, meaning that all 7 do not stand. Instead, only 4 of the charges can be, well, not charges in the civil case, only 4 of the claims can be retried. These are false imprisonment, the battery, medical negligence, and then there is a 4th that can also be retrialed, the intentional emotional infliction, rather, of emotional distress claim.
Yeah. Let's bring in Mackenzie Joy Brennan. Wow, this is a shocker. And, you know, there's such a huge finding in terms of damages by this jury. It was a case that we watched play out over 8 weeks. It was a long one and a ton of emotion. Your take on this and then the next steps, what's going to happen?
Yeah, I mean, this is such a tough case on so many fronts. I feel like it's an intersection of all these issues that are so easily misinterpreted on both sides. You have a complex, difficult to diagnose and treat, rare pain disorder on the one hand, and those are so often misunderstood. You also have a parent especially dying by suicide, and that can often cloud people's judgments. I'm not saying that's necessarily what happened here. And then Munchausen by proxy is something that, you know, relatively misunderstood by the public at large, maybe overrepresented in commonality because of how bizarre it is when we do hear about cases. But I could see that influencing a reporter, a mandatory reporter, which obviously comes into play here with that kind of Good Samaritan protection statute that's now been reinterpreted on the appeal. So many pieces that will make this, I'm sure, difficult even on the retrial. And you think about the folks left behind, especially the daughter, having to go through this process again. And obviously the intentional infliction of emotional distress tends to be one of the more difficult claims to prove anywhere. And I imagine if it's standing in greater isolation now and the impact that may have on evidence, it's going to complicate it further, or potentially make it harder to prove.
And once this is brand new breaking news, once we've been able to do a deep dive and read the opinion, we'll know actually what law the Court of Appeals says that the trial court misinterpreted, because obviously it's a legal basis. They've said now you have to retry. These 4 are the only claims that can be retried. But the emotional aspect of this, I watched the Netflix series. I watched every day of trial here on Court TV, and the emotion of it all, the emotion of the father, the emotion of the child, the emotion of those at the hospital on videotape, because they believe that the mother made this up and that nothing was wrong with the child, versus the parents saying, no, clearly something is wrong with our child. We've done nothing wrong. It's a very emotional case, which is why I would suspect that even upon retrial of 4 claims, a jury might find still against the hospital and still might find damages against the hospital. What do you think, Mackenzie?
Yeah, I think you're right. It's certainly, as all of us know, because of the Netflix documentary, it's really, really hard to even think anything that would cut against, especially the daughter's interpretation of things. Based on my preliminary reading, it looks like the misinterpretation that the appeal hinges on is this Florida law that essentially is a Good Samaritan type protection that I think immunizes the mandated reporters against claims like this. And they're saying that the lower court misinterpreted that in the verdict itself. So that I could see interfering with a lot of stuff and potentially with damages too.
All right. Again, the breaking news, appeals court reverses that civil decision and that huge judgment.
I'm still in a state of shock. I mean, a girl is in a hospital bed in severe pain. Her mother is being charged with her abuse, which was unproven, and now her mother isn't even here to defend herself. And this appeals court rejects the whole case. Not just this. First it was toned down from 250 million to 213.5 million, and now it's a reversal of judgment. I mean, if we're gonna do right, people, we gotta do it right all the time, you know. And as far as I'm concerned, we're talking about justice. Honestly, this is justice denied. Try again. We'll just have to wait and see what the Kowalski family will do at this point, because right now, like I said, it's a total case of justice denied. Next up, we're gonna get right back on track under justice served. A woman is sentenced for aiding in her son-in-law's campground murder. We're in Canyon County, Idaho. Take a look at the right side of your screen. On the left is Melissa Calimpit, and on the right is Rosalie Morris. A Nevada woman, Morris, was sentenced to 30 years in prison for aiding in the murder of her estranged son-in-law. 60-year-old Rosalie Morris must serve 18 years of that sentence before she's eligible for parole following her October 23rd sentencing in Canyon County Courthouse in Idaho. Morris was arrested in July 2024 on allegations that she helped her daughter, Melissa Calimpit, plot the murder of 37-year-old Travis Calimpit. Travis was found dead at Martin's Landing campground on July 12th. He had been fatally shot in the chest. Morris and Melissa later disposed of the gun and the victim's cell phone. Melissa and Travis were married in 2010, had 2 children together, but court documents said the two were estranged and had previously divorced in 2018 and remarried in 2020. At the time of their arrest, Melissa told investigators she was forced to leave their house in Parma in April due to Travis being physically abusive to the children. Melissa told investigators that she planned to meet with Travis on July 12 to inform him that she wanted a second divorce. Documents state dashcam footage from one of the vehicles at the campground captured Morris's 2003 Toyota Highlander parking in the area to meet with Travis. When investigators presented the footage to Morris, she admitted there had been a family meeting at her house in Nevada the day before, on July 11th, where she spoke with Melissa and 2 other individuals about how they could get rid of Travis for good. An affidavit said Morris had also admitted that she planned to kill Travis on July 12th and told investigators that she searched for an unregistered firearm to use in the murder. Morris reportedly told investigators her initial plan was to make the trip to Martin Landing alone, but Melissa wanted to join her. Melissa reported reportedly admitted to investigators that she knew of the plot to kill Travis and says she told Travis to meet her at the campground alone. Documents state Morris hid in the campground bathroom while Melissa talked with Travis. Court documents indicate Melissa changed the story multiple times while talking to investigators about what happened at the campsite. Initially, she claimed Travis raped her, but later she said she bludgeoned Travis with a rock and shot him when he charged at her. In one version of the story, Melissa claimed that Travis took the gun and racked around into the chamber. According to Melissa, after Travis was shot, he pleaded with her and asked her why, to which she responded, oh, here's one I've heard before, "I'm sorry, I love you," before running away. Melissa says she took her gun and Travis's phone and asked Morris to take her to CJ Strike Reservoir. On the drive, court documents says she threw the SIM card out the window and then tossed the phone and gun into the water. Travis's sister Anna Norris told the court that the victim was a brother and uncle who was loved by those around him. He didn't deserve that. He should still be here with me and my family. This is about the most extreme crime that people can commit, said Canyon County District Judge Randall Grove during the sentencing hearing. Your goal was essentially to treat Travis Collinput like a dog, to put him down. Whew. Which end of that story was the truth is what I want to know. As far as Melissa's side goes, she said, honestly, I'm more inclined to believe the part about she bludgeoned him with a rock and then shot him. And then when he tried to reach for her and ask why. Now here's the wrestling fan part. Here's a wrestling fan in me coming out. She pulled the Shawn Michaels to Ric Flair piece when he said, "I'm sorry, I love you." The difference is Shawn Michaels didn't kill Ric Flair. All he did was hit him with a super kick and 1, 2, 3 was done. This, on the other hand, "I'm sorry, I love you," ends with a man dead. And her mother was a part of the plan, then she should do every bit of the 30 years she gets. Forget about the parole. She should do every last bit of the 30 years she's sentenced to. As far as I'm concerned, justice served. All right, speaking of justice served, I got one last one to bring to you. And that is the sentencing in the drive-by murder, may I add, of Suni Bell in Florida. Zavante Sampson and his co-defendants were sentenced today for that one. Let's see, am I going to go to that right now before breaking down the sentencing, or am I going to give you the details first? Oh, that's the verdict right there. So it looks like I'm going to break down the sentencing of all of it. All right, here's the deal. 5 men convicted in the drive-by shooting that killed 4-year-old Suni Bell. All were sentenced to life in prison without parole. Savante Sampson, Quandarius Hammond, Jalen Bedward, James Denson, and Andrew Thompson were tried together for the August 22nd, 2021 incident. All 5 men were found guilty of premeditated murder in the death of Bell and guilty of the first-degree attempted murder of the child's mother, Mary Harrison. Sampson and Hammond were additionally found guilty of the first-degree attempted murder of Willie Brown, and Thompson, Denson, and Hammond were found guilty of conspiracy to commit first-degree murder of all 3 victims. As for the lesser included charges, all 5 defendants were found guilty of shooting at, within, or into a vehicle. Denson, Thomas, and Hammond were found guilty of discharge of a firearm from a vehicle. In their opening statement, prosecutors said Bell was riding in the back seat of a vehicle with her family when 3 cars pulled up and fired 40 shots at the vehicle. Bell was killed in the shooting, while her mother and uncle survived. At a hearing in January 2024, prosecutors reportedly called it a coordinated attack. Prosecutors said surveillance video from the area shows the moments before the shooting. In their opening statement, Sampson's defense attorney urged the jury to consider each of the 5 defendants' actions separately and said the story is in the details and not the prosecution's surveillance video evidence. The defense attorneys for the other 4 defendants also urged the jury to consider their actions separately. So let me do a little math here. 5 defendants, 3 victims, 2 cars, 40 shots. 40 shots. $40 divided by 5 is 8. Eight divided by 2 is 4, which is the age of Suni Bell at the time she got shot and killed. And there's all these other different charges of discharging a firearm, this and that. The biggest charge of it all is all 5 of you committed murder. So that means 1, 2, 3, 4, 5 lives being wasted. Five men being sentenced to life in prison without the possibility of parole. This is what I mean when I said earlier in a different case about not doing the crime if you can't do the time. Now these look like the kind of guys that could probably say, "Oh, I can do whatever sentence they originally thought standing on my head." Well, my suggestion to you, gentlemen, is this: stand on your head for the rest of your natural lives, because that's how long you're going to be in there for. And with that, I'm going to wrap this up with a closing statement, with a closing argument, if you will. Justice can be beautiful and justice can be ugly. Well, when there's no satisfaction in it, what is it really? As the gavel falls on these 8 cases, one truth echoes louder than any verdict. Justice is not a one-size-fits-all outcome. It's a mosaic of decisions, delays, and determinations shaped by evidence, emotion, and the limits of the law. For some, justice was swift and clear. For others, it remains elusive, tangled in appeals and procedural pauses. These stories remind us that justice served is not always justice satisfied. And in the court of public conscience, the final judgment may still be pending. I want to thank you all for joining me this week for the Mid-Week Byte. This Friday, for the final word, I'm going to tap into something I heard from Julie Grant this morning on her opening statement show on Court TV. Now, keep in mind, last week I did a missing persons spotlight on Melody Buzzard. I got word early this morning that Ashley Buzzard, Melody's mother, was told that she had 72 hours to produce Melody, or she would face charges. The 72 hours had passed. So Julie Grant is asking the same thing I am. What's taking so long? Or, if I could use the words of the Dukes of Hazzard's Sheriff Roscoe P. Coltrane, where's the cuffing and stuffing? Ashley Buzzard should be cuffed and stuffed right about now. I'm going to talk about that, and I'm going to go right back into her case and back into her timeline just to find out exactly what in blazes is going on there. Why isn't Ashley talking? And the biggest question of it all, where is Melody Buzzard? We'll do all that in the final word on Friday. For now, again, thank you all so much for joining me. I'm Ernest Bethea, the Last Outlaw. This is Bethea'S Byte, and it's reloaded.
Thank you all for joining me here at the Drama-Free True Crime Destination. Be sure to follow Bethea'S Byte Reloaded all over social media and get your coverage of true crime news with no gimmicks, no drama, and no BS. This is Bethea'S Byte, and it's reloaded.